Good morning. Welcome to Cannabusiness Live. I'm Travis Copenhaver. I'm joined today by my colleagues,
Nicholas Gwendez
and Jennifer Domingue.
And we're here today to talk about a very exciting week in cannabis in Michigan here. But first, we have a new associate with the Cannabis Legal Group. Jennifer, why don't you introduce yourself, say a little bit about yourself.
Thanks, Travis. My name is Jennifer Domingue. I am the new associate attorney here, and I have a couple of years of experience in litigation, business law, and cannabis law. I'm really excited to join the team here, and I think that our collective experience is very well-rounded now, so I'm really looking forward to working with all of you.
Yeah, and Jennifer definitely brings a lot of different perspective to our overall suite of services, and we're very excited to have her, so welcome.
Thank you.
Yeah, so let's get right into it. We've had three pretty major things happen in Michigan cannabis this week. First, on Monday, the Bureau of Medical Marijuana Regulation Board met and had a pretty exciting meeting. We have a bunch of now newly approved Step 1s and some additional fully, potentially operating licensed businesses as soon as they finish up their payments and things. Tuesday, the state of Michigan issued new emergency rules that extended the ability for some of the temporary operators to continue and stay open as they seek licensure. And then on Thursday, late into the afternoon, we had an injunction passed by the Court of Claims on some of those emergency rules. And we're going to kind of dive through those different items as we go here. So Nick, we're going to start talking about just a quick summary of what the board talked about on Monday.
So it was definitely a packed meeting in terms of how many the board had to go through. They went over 60 Step 1s, 60 total application reviews, 30 Step 1s, and then a mix of 30 Step 1 and Step 2 various reviews. I don't have the particular numbers as far as how many were actually approved or denied, but it was definitely another additional set of data for us to kind of look at and what the board's thinking of and continuing to process through many applications.
And we've marched through why applications have been denied, how many are getting denied several times now. I think at this point, people who've been following along the board have a general understanding of what the board's looking for, what types of items are causing disqualifications. Based on the numbers before this Monday meeting, we had 73 approved and 53 denied applications at that point. That's a success rate of about 58%. So the process has been pretty strict. But there aren't really very many new revelations about why applications are being denied. Mm-hmm. More the same from what I saw. So any thoughts?
Absolutely. I think it's continually a failure to disclose. We're seeing a lot of reputation issues, but mostly it's looking at criminal issues and civil litigation failure to disclosures. That's what we're seeing right now.
Yeah, and I think now that we have a lot of this, data set from several board meetings, it's a little bit different now for potential applicants, right? I mean, I think that before there wasn't really a good or a bad way to say, who should be on an application, because it was all kind of, well, we can try this and put it together and see what the board actually decides. But now I think it's really important for all applicants to kind of, if you can't remember your criminal history, you really need to think very hard about any interaction that you had with the police. You need to go and get iChats. You need to go and do FOIA requests at those potential jurisdictions and locations where you might have had an interaction, because if you don't find those, it may lead certain board members to say, okay, that's an automatic no because it was a failure to disclose, even for some things that might be hard for you as an individual to kind of pinpoint as being an arrest or needing to be on the thing. So you can't feign ignorance anymore or say that I forgot, because we can see now that those things definitely make a difference no matter what.
Right, and I think it's important to understand as well that these are large projects. There's a lot on the line, and the board expects you to take it seriously. If you're not going through the effort to try to track down this information, it's been made very clear that you need it. So to just assume that it's not going to matter, I think has proven itself to not be the case. So if you're going to be on one of these applications, make sure you're taking it as seriously as possible. If you're going to put all this information and effort into getting a license, take the additional effort, try to go find that information. And if you can't, do the next best thing. Show you tried. Acknowledge that the state needed it and you were unable to get it, and explain why you were unable to get it.
Absolutely. The more information that you can provide to the board, the more likely they are to read that, understand that, and really give consideration to the fact that you are being as upfront and honest to them as possible.
Mm-hmm. Because again, kind of a common trend is that you don't want to be on the defensive. You don't want to have to be explaining yourself after the fact. And a lot of the times, I think people might be complacent in, okay, well, I don't remember anything. I don't have any records about it. I'll just go ahead and put no on Disclosure 7 SA. And if they come back with something, I'll thoroughly explain it. But what we've seen is that you get one shot to actually outline any incidents, arrests, charges, convictions, indictments, plea of no contests, incarcerations, things like that. And if you don't outline that 100%, that could potentially doom the application. And that's a really serious thing to be thinking about when you're putting so much money into getting this all prepared and the whole rest of the application process.
Right. And it's also important to remember as well, there's no deadline for most applicants at this stage. If you're not ready to submit an application, you shouldn't just rush to get it in. Take your time and do it right the first time. If you know information's missing, find that information. The state of Michigan doesn't have a deadline for an applicant unless you're one of those few temporary operators and you've been well aware of what your requirements have been for the last several months. You've known since February when you put your application in what the process has been. All other parties who are doing this for the first time to get those original applications in to license and conduct the first time, don't feel like you need to have this in. Some cities and municipalities are rewarding those applicants that can get their information in and approved first. That's a trend that I don't personally agree with, but it's one that you're making an educated decision about when you're targeting those markets. But for the average applicant, it's incredibly important to have a complete application, and that's going to, in the long run, be the fastest thing you can do, the highest success rate to put that effort in up front.
Mm-hmm.
So.
Absolutely. And keep in mind that there's a fine line between an explanation and an excuse. When the state asks you to explain something that they found in a deficiency letter, it can come off as an excuse. You might say, okay, well, now I'm going to take the opportunity to really explain myself and, I can explain this away. But the state will say, we've already looked into you, we found these issues, and now whatever you tell us, thank you for that information, but it might be just considered an excuse at this point for why you failed to disclose in the first place. So really make sure you're taking the time to think critically about any arrests, any even traffic violations, bench warrants, anything like that that might be a red flag, as well as any civil litigation, divorces, child custody cases, bankruptcies, anything like that you think might have a possibility of showing up at that moment when they're doing the investigation, because if you wait too long, it can look like an excuse.
Mm-hmm. So like we said, exciting board meeting, more approvals, more denials, and we'll continue to report on that as they occur. But in anticipation, and we can circle back if people have questions about it, please feel free to chime in at any time. But the very next day, and then they had told us this was coming, we got new rules regarding the status of temporary operators. I think as everyone was aware of, September 15th is tomorrow, and that was the next deadline for when those businesses that hadn't yet achieved licenses would have to shut down. And there's a lot of news articles floating around about big cities like Lansing, for example, shutting them all down. They're taking a position that none of their applicants, regardless of where they are in the process, are crossing the threshold to stay open. All kinds of buzz about it. Jennifer, what exactly was that bulletin? What's happening?
Okay, so there was a bulletin that was released that essentially kind of dictated when certain temporary operators would have to shut down and how many would be able to remain open. So if you had your attestation E signed and you were temporarily operating, there was a deadline on June 15th. And so that was the original date that you had to have your Step 2 application in and ideally have a license by that point in time in order to remain open. That deadline got pushed back to September 15th. On Tuesday, the state said that if you don't have your Step 2 application in by June 15th, there's a couple of dates
we
here.
asked her to memorize all these dates.
By June 15th, then you have to close your doors by the end of this week. Now, there was really not much guidance from the state indicating that this was going to be the rule. It was an issue that many of our applicants saw that they needed to get this in by June 15th. However, when they extended the deadline, many people didn't submit all of their application materials because they had an incomplete application, such as attestation I. A lot of municipalities didn't have ordinances in place, such as Detroit, Flint. They didn't have the ordinances in place. They couldn't sign the attestation I's. I know Lansing had an issue with that. And so without a complete application, a lot of currently operating facilities would have missed that deadline. And so now we have about 98 facilities that are expected to close according to the LARA advisory bulletin.
And I mean, I think too, there was a lot of moving parts here. The original deadline was February 15th. So it was our position and our interpretation of the rules as they were at that time that you needed a step 1 and step 2 in by February 15th. Now, whether LARA was certain or clear about that deadline, it seems like they kind of, were giving a little leeway to those applicants. And so they continued to allow those existing facilities to, apply for step 2 and have those narratives in by a certain date. And so the target keeps moving. But then, as we came towards this board meeting, everyone thought, and I think LARA had clarified, we don't think that we're going to be able to extend the deadline. So for all intents and purposes, everyone thought all of these existing facilities thought they were going to have to close by this Friday, which means getting rid of all the products that they have that haven't been tested and kind of throwing a wrench in the whole system where patients all of a sudden, they lose almost 50% or so of the existing facilities. And that would have kind of created a huge problem with the industry, given that before this Monday meeting, only 16 or so, I think, of actual facilities were up and issued a license, let alone, I don't know how many had paid the regulatory assessment fee. So I think this was kind of a very short-term, spur-of-the-moment change that I don't think a lot of people were expecting.
Right, and we, talked about temporary operators on the show several times, and not to retread too much territory already, but let's remember that when the MMFLA was originally drafted, there's nothing in the statute regarding an ability to operate temporarily. That is something the emergency rules created based on the demands that public, primarily patients were presenting to LARA. They put it in Rule 19. It originally was June. Patients realized that these applicants were moving fast enough, and the state's doing what it can to do something that they really don't have the means to do. Nothing in the MMFLA gave LARA the true ability to create a temporary operation kind of transition period, but they did a pretty commendable job trying to. And when June wasn't enough time, they pushed it to September. And they tried to do what they could based on the constraints that they're operating under, push it even further for some of the applicants that were doing what they needed to do in the application process. And obviously, at some point, the temporary operators need to be full operators, and that means there's application requirements that they needed to have in. And obviously, no one wants the patients to be cut off access to their products, but at the same time, these applicants have known since February what the application requirements are. And to the ones that put all their information in and are waiting for an agenda, I think LARA is doing a good job of trying to prioritize those applications. But for the ones that were in between June and September and didn't have Step 2 materials in, they knew they needed those materials in before June. So LARA is understandingly, trying to get these applicants to do what they're supposed to and put their information in. They can't say whether or not you qualify for a license if they only have half an application. But at the same time, they're also reflecting on the reality that this is jarring to the consumers, the patients that need this medication. So, they're not in the easiest position to be in, and we might not agree with the way they tried to deal with it, but, at least they did try, and they're doing what they can. They're a regulatory agency. They're not the legislature. They don't really get to make up new laws. That's the role of our Congress. So, understand the position they're in and what they actually can do. But, they extended the rules. There was a lot of concern about what those, rules were. And, it was going to have the unfortunate impact of shutting down about 98 or so temporary operators. So on Thursday, we have more news. What happened on Thursday? Unless you want me to
talk about what happened on Thursday. So
sure.
On Thursday, there was a Judge Stephen Borrello from the Michigan Court of Claims, who filed an injunction stating that the state cannot force these temporary operators to close if they are delineating who needs to close based on this June 15th deadline. Mm-hmm. So there's a lot of reasons behind the scenes of why this ruling came down, but I think the main one is to protect the patients.
Right. Yep. And again, no one wants the patients to have to not have access to medicine. The judges don't, LARA doesn't, the Bureau doesn't, the applicants obviously don't. But that doesn't mean we can just do anything we want. We're constrained by what the statute's created. We're constrained by the system. And, it takes time, unfortunately, for governments, and there's, processes they have to go through to accomplish different goals. So effectively, the Court of Claims is a statewide court with limited jurisdiction to review challenges against the state of Michigan and its agencies. There was a claim filed, and the judge basically enjoined LARA from treating temporary operators differently based on when certain materials were presented, is my understanding of it.
And so what I'm thinking happened is that this was a, temporary restraining order. And so there was very imminent harm that I think the judge found with this happening, brought on behalf of a temporary operator. So not only, I'm not sure on behalf of all temporary operators or what the actual position of that was, but certainly the claim would have been that this decision by this state body was causing immediate irreparable harm, and the public interest weighed in the balance of granting that until further hearings can be heard in about 2 weeks, upon which the Court of Claims will again issue a more permanent injunction if they believe in the favor of the temporary operator that did bring this suit. So this story definitely isn't over yet. Just kind of throws another wrench in the whole framework, because now LARA established this new emergency rules that had all of these different deadlines, and now apparently all of them can continue staying open, at least for right now, until December 15th. So if the ultimate outcome of this litigation is that that LARA prevails, then all of a sudden, they have temporary rules that were in effect but weren't, and then there was a deadline but there wasn't. And so what about that conduct between September 15th on? That has to be kind of taken into account too. So it's definitely, a moving target. I can see it's frustrating from a lot of different interested parties, patients, potential operators, applicants. It's very interesting to see these things play out and these things change daily.
Right. And it's, a lot of moving parts here. It's obviously in the short term, very good for patients that depended on some of these operations that might have had to shut down Saturday. But if, for those operators, I would still be incredibly cautious, as we've counseled almost every time we talk about temporary operators.
It's always been at your own risk.
Right. And it will continue to be at your own risk. And now that things are called into question, depending on how that all plays out, you're going to have to be adaptable to, the court decision. So,
and I think what we've seen too is that the board is looking at social media. They talked a few times during the meeting about them taking social media posts and having that in LARA's report. So if you can think about it now, for temporary operators, while you're allowed to continue staying open at your own risk, those things could potentially lead you into traps if you're not careful about social media or things that might be viewed by the board as a potential blemish on your application and a reason for denial. So it's always been, be safe, show a good faith effort towards compliance, keep responding to deficiencies timely. I think there was something in there where there were 20 before and then there were still 20. So they do pay attention to both the tempo and the pace and the responsiveness of everything, and looking at social media, Facebook, Instagram, all of those kinds of things to get a full picture about all of these applicants. So it's still at your own risk. Be careful.
So we have a pretty good question here we can dive into. So James asks, if I can get this to work here, do you think if somebody operates past September 15th is going to jeopardize their license? And that's an interesting question, because depending on how this current issue plays out in court, then, maybe not. I think that as long as you are very careful to only do what you can do as this proceeding plays out, and as LARA responds to it, and as they issue more guidance, and you are making a good faith effort to only do what you were supposed to do, what's set in stone is what you're supposed to do, then it's likely to not be as impactful on your ability to operate if you happen to stay open past the 15th. That being said, I've cautioned any temporary operator from being open in general, so it's always at your own risk. There's bulletins that state it won't be held against you, but LARA puts those bulletins out and the 5 board members vote on it. So they don't necessarily, there's no guarantee that they're on the same page about anything. So
I agree. And I think that there's a difference between, if you continue to operate, it's going to eliminate your chances of getting a license, versus it's going to be a little red flag that appears for these board members. And if you have enough of those little red flags popping up on your application, they're going to consider a motion to deny. So just be cognizant of that.
And I think the way that the language in the rule is worded, it won't solely be counted against you. So what that means is that if they find you're a temporary operator, they're not going to just say, oh, okay, I'm denying them for that reason. But once they find that out, it's the next step about what they justify as that, because I think that they've found a lot of similar fact patterns with certain temporary operators. And that hasn't meant that all of them have been denied. We've seen close votes. We've seen 3-2, 4-1 votes to approve. So it's not the full picture, as we've always said during these meetings, but it's always definitely, it's not a safe harbor to be a temporary operator under Rule 19. It's just that they can't automatically say we're not going to pre-qualify or approve this license for you being a temporary operator. It's what happens after that. What do they find? Right. What do they see that might be troubling to them as you're trying to enter into this regulated market?
Right, and let's remember what the board is thinking about if you choose to do that. They are trying to determine, among a lot of other things, are you an applicant? Is this group of operators going to be the type of operators that can function as a regulated business? If you're unable to follow the rules our regulators set, that's going to be problematic if they decide whether or not to give you a license, because you're expected to follow regulations as you operate into the future. And if you create a pattern or practice of not doing that, then that's going to be something held against you.
Absolutely.
So, great. So we have another question about Michigan State Police cracking down on certain types of marijuana. There was a Court of Appeals case recently that created some problematic conditions onto what is and isn't usable marijuana. That question effectively, and just to kind of summarize it so we can talk about it, under the 2008 Medical Marijuana Act, patients and caregivers can be in possession of, depending on their relationships with one another, up to 12 plants per patient, and a caregiver can provide to a patient, or a patient can be in possession of up to 2.5 ounces of usable marijuana. The case at issue that's being asked about regards what is usable marijuana. There really isn't a definition of usable marijuana in the 2008 Medical Marijuana Act, and unfortunately there was a court case that made it very difficult to qualify certain types of off the plant prior to being usable marijuana as non-usable marijuana. And what happened in that case is the defendant was trying to argue that the materials at issue were not usable and shouldn't have been held against that person as part of its 2.5 ounces. Michigan State Police, the prosecutors, were saying it was under the definition of usable marijuana and should be counted against them. Unfortunately, that case did not go the way the defendant needed it to, and now we have some precedent on the books that makes it very difficult for anyone harvesting their materials to stay under their limitations. Any thoughts on that?
And I think the response is that there's a document that the Michigan State Police uses as a kind of guide to its officers, and they updated that guide with that case law. And that case law, we believe, and I think a lot of attorneys across the state believe, is wrongly interpreted and should go up to our Supreme Court in Michigan and should be overturned, because it really creates an inconsistency and probably an impossibility in the law between caregivers and how they can grow. Where it's on the plant and it's completely fine and they're under their limits, but as soon as it's cut and it's drying, all of a sudden they're over their limit, and it makes it so that almost no caregiver can be practically in compliance. Now, whether or not this is going to really impact, it definitely is going to have an impact. I don't think it's going to cause a huge alarm with certain law enforcement officials and things like that, but it definitely raises an issue if you are in the process of any kind of criminal charge or search or something where they do then, they are able to use that law to potentially, against you and right. cause yourself trouble. So.
I feel like the timing of it all is very unfortunate as well. Obviously with the current guard of provisioning centers getting, forced to close, not getting up to licensing enough, there's going to be a lot of patients that had previously relied on those types of stores now having to either go back and create their own product or work with caregivers again, and putting patients and caregivers in a position where it's difficult to legally operate as patients and caregivers doesn't exactly line up well with LARA and the board effectively making those patients have to rely on patients and caregivers because their point of sale is being limited at this time. So, obviously I don't see any sort of grand, intention with the way things are playing out, but everyone should be aware that as laws change, there's transition periods. Things might not be great for medical marijuana in the short term, but there is promise to having a better designed system if we can get through the turbulation and get to the point where the industry has its feet on the ground and it can actually grow. But for patients and caregivers right now, as the demands upon you grow because we're waiting for some of these businesses to get up and running, you should be very careful because, unfortunately, if you're outside of the protection of the Section 4 defense, 2.5 ounces of usable marijuana, you have to rely on a Section 8 defense, which can be very difficult to do in some cases. So be careful out there. Always be cautious. Remember, if you have a grow and they don't just get to walk right into it. You have to give them a reason to. So be responsible neighbor, be cautious and careful with what you're doing. Do your best to try to stay legal when you can. And, understand that if something, takes you out of compliance, work to become back in compliance as soon as possible, and just be cautious that there's risk with that type of conduct.
Absolutely.
All right. Any other questions, guys?
I guess just before we wrap up, I did want to mention as well that there was another issue addressed recently about, applicable to applicants, is that the regulatory assessment fee for the fiscal year 2019 is actually kind of a surprise and a little bit higher. And I think projection-wise, and just the complexity of the application process led to those figures. They had originally said that for this past year or so up until now, the regulatory assessment fee for most license types was $48K. They gave that updated number for the fiscal year 2019, and it's now $66K for all the license types except for Class A's, which is capped at $10K, and safety compliance facilities are at $0. So that's definitely another factor that applicants are going to have to take into account within their budgets. It's definitely, almost $20K increase per license for the regulatory assessment fee, which definitely kind of, stresses those who might be a little bit thin on capital. So I think that's just kind of interesting. It's another change. It's another moving target, something that applicants are just going to have to deal with.
All right. You should project that in your budgets moving forward. And remember, these fees are yearly. So as you renew them, we can expect them to be somewhere around that. Brad has a question about, the problem with being a caregiver and trying to be a supplemental applicant and part of this application process. Any thoughts on to what caregivers need to be thinking about if they are, one of the supplemental applicants? I know we had a whole show on this, where Nick and I walked through base questions. But
I think that the key to being a successful supplemental applicant as a caregiver is making sure that you can explain your caregiving succinctly when they're looking especially at your financials. Did you report this to your taxes? Were you upfront and honest about your caregiving activities? And if you're clean and you can explain everything, then it's not going to have a negative impact. Now, some board members might still be hesitant about that, but overall, the state understands that caregiving is the base of the medical marijuana industry at this point in time. And so they want those people who have that experience to be involved, but they also want to make sure that the caregivers that are getting getting a license are doing things the right way and can show that they followed the law, the ordinances in place governing that at that point in time, so that they can show that they're going to continue doing that in the future.
Mm-hmm. And I also think it's important to remember that even though we have a board right now, they have limited terms. I think somebody had mentioned in a comment that I read a little bit on another article that Nicole Cover, I believe her term ends the soonest. So depending on who appoints the next person and who that person is, that could change the vote drastically. I mean, you might see some 3-2 votes become 2-3 and so on and so forth. So that's going to be a changing target as well, because we might have, if certain board members who are more favorable to certain fact circumstances get not removed, but just their term ends and they get replaced by somebody new, that creates a whole different dynamic between what is and isn't allowed. And I just think generally right now it's new to everyone. The board, in my own personal opinion, is being a little protectionist, but this is what they're tasked to doing, especially just for caregivers. And I think that, in time that protectionist quality might go away once they have had other caregivers enter that have been approved, that are good operators, that do kind of shed a good light on those that, one bad apple ruins the bunch kind of mentality. And I think it will clear up in the future. It's just right now there's a lot of growing pains and learning, and things just haven't shook out the right way, given, we can't change what happened in the past, can't change the market and the conditions that they operated under at their own risk. Even though they are now showing that intention to comply and enter the regulated market, it's kind of a hard learning process for how some of those might, past conduct might have hurt that from happening. So.
All right. So remember, if there's parts of the way this whole system's designed that you think bears, critique or improvement, you have an opportunity to talk about the proposed rules on Monday in Lansing. They're having a public hearing, as we mentioned last week, to hear public comment about those proposed rules. And if you feel like there's areas that additional information could improve this system, speak up. Put a public comment in, or you can submit public comment in writing as well. And we encourage this industry and the passion that we see demonstrated by a lot of individuals to make that passion known. And as we mentioned last time, be strategic about what you're trying to get done. Tell them with knowledge about what they can and can't do, what you suggest that they start doing. But, participate. They've listened to patients. They might not be able to do what patients truly want, but they've done their best to do what they can do for patients and allow temporary operation and continue to expand it as they can. And, that will be critiqued and challenged if it's done in ways that certain individuals think don't pass legal muster, but we'll bear through it as it goes. So and as we continue to hear updates about how that whole issue is playing out in the court of claims, and as we hear other updates about marijuana news, we'll be happy to report it to you. As always, if you have questions after the show that you'd like us to address, we'll try to jump into the comments and answer the ones that we can. But thanks so much for joining us this morning. For Travis Copenhaver,
Nicholas Melendez,
and Jennifer Domingue.
Thanks so much. We'll see you next week.